previous chief executive isn't facing charges as a single accused party. He's being prosecuted as the purported leader of an illegal organization. Within Fulton County, a grand jury has issued an indictment targeting Donald Trump alongside 18 additional co-accused under Georgia's legislation addressing racketeer-influenced and corrupt organizations. The accusation, a synchronized campaign to reverse the 2020 presidential electoral outcome in the state following Trump's defeat to Joe Biden. Stop there. This transcends a limited electoral disagreement. This represents the apparatus of a state criminal framework positioning a former president as component of an organized operation. Fulton County District Attorney Fani Willis has clarified that this constitutes a state-level prosecution, not federal, not merely symbolic. A state criminal matter alleging that from November 2020 extending through January 2021, a structured collective functioned with unified purpose to unlawfully modify Georgia's certified electoral result. Allow me to restate that so it properly registers. The accusation isn't that Donald Trump executed isolated actions. The accusation is that an operation existed and that he participated within it. The indictment spans nearly 100 pages. It documents over 160 particular actions the prosecutors contend collectively constitute a configuration of racketeering conduct under Georgia legislation. Telephone communications, gatherings, declarations, paperwork, synchronized steps, each presented not as arbitrary occurrences but as interconnected maneuvers inside a framework. Here's where you must comprehend the institutional significance of that term, racketeering. The federal RICO legislation was established in the 1970s to target organized crime leadership. The architecture was straightforward but potent. Prosecutors could charge leaders who didn't personally execute every underlying offense, but who directed, synchronized, or profited from an illegal network. Georgia possesses its own RICO legislation. Legal scholars have extensively noted that it's more expansive than the federal variant. It encompasses more categories of behavior. It provides prosecutors more structural adaptability. It permits them to connect multiple actions into one operation framework, even where federal prosecutors might encounter difficulty. This is where the narrative transforms from an electoral disagreement to a confrontation with institutional architecture. According to the indictment, the purported operation consisted of Donald Trump and 18 additional individuals. The declared objective reversed Georgia's electoral result after the state proclaimed Joseph Biden the victor. Prosecutors contend this collective acted in concert, not sequentially, not accidentally, but with synchronized intention over several weeks. Fani Willis has stressed that this case isn't regarding one telephone communication or one filing. It's regarding a sustained and structured scheme. A scheme with roles, a scheme with coordination, a scheme that, in her assessment, crossed from political advocacy into criminal behavior. The superseding indictment introduces 13 new accusations. At its nucleus is the RICO violation itself. Surrounding it sit additional counts that prosecutors contend functioned as foundational elements of the larger operation. The defense response has been immediate and vigorous. Representatives for Donald Trump have characterized the indictment as politically driven. They contend that every action undertaken was component of a lawful effort to contest electoral outcomes. They frame the prosecution as an attempt to criminalize political expression and challenge. That defense theory isn't peripheral. It proceeds directly to the First Amendment. It proceeds to the boundary between aggressive politics and criminal conspiracy, but prosecutors counter that the behavior alleged extends beyond litigation or rhetoric. They indicate pressure on state officials. They indicate allegedly fraudulent declarations. They indicate documents described as counterfeit. They reference alleged unauthorized penetration to voting machinery. In their assessment, the boundary was violated. And here's the institutional gravity drop. This is a state case. If convicted, Donald Trump could not grant himself pardon as President of the United States. The pardon authority for Georgia state offenses resides with the Georgia State Board of Pardons and Paroles, not the White House. The constitutional barrier between federal executive authority and state criminal power isn't theoretical here. It's operational. This isn't normal. Legal analysts across the spectrum have described this as potentially the most severe legal challenge Donald Trump has confronted. not simply because of the quantity of accusations, not simply because of the indictment's length, but because RICO restructures accountability. It treats coordination as culpability. It treats operation as vulnerability. Instead of asking, did he execute this action, the court may ask, did he participate in a framework that executed these actions? That's a different battleground. And once a state deploys its organized crime legislation against a former president, the inquiry ceases being about one accused. It becomes about how extensively state criminal legislation can reach into the behavior of national political actors. And that's where the genuine collision commences. Now we shift from accusation to architecture. Georgia's RICO legislation isn't vague, it's engineered. Prosecutors must establish 3 pillars. First, the existence of an operation. That operation can be a formal organization or an informal association of individuals functioning together. Second, a configuration of racketeering conduct, at minimum 2 qualifying actions within a 10-year time frame. Third, participation. The accused must have conducted or participated in the operation through that configuration. This isn't regarding optics, it's regarding structure. According to prosecutors, the purported operation functioned from November 2020 through January 2021. Its objective, reverse Georgia's presidential electoral result. Time-bounded, goal-oriented, synchronized. More than 160 actions are enumerated to support that structure. Prosecutors described telephone communications and gatherings with state officials allegedly designed to pressure them to modify certified vote tallies. They cite declarations that they contend were knowingly fraudulent regarding electoral fraud. They reference documents described as counterfeit, connected to efforts involving alternate electors. They include allegations connected to unauthorized penetration to voting machinery in Coffee County. They indicate coordination among attorneys, advisors, and political operatives. Each action standing isolated might invite debate. Together, prosecutors contend they constitute a configuration, and that's the pivot. This case doesn't rise or fall on a single conversation. It rises or falls on whether a jury perceives a configuration. The 13 principal accusations reflect that design. 1 count alleges violation of Georgia's RICO legislation. 4 counts allege solicitation of public officers to violate their oaths of service. 1 count alleges making fraudulent declarations to a state agency. 2 counts allege conspiracy to execute forgery. 2 counts allege conspiracy to execute forgery. 2 counts allege conspiracy to defraud the state of Georgia layered. Interlocking constructed to reinforce the tape and computer trespass. 1 count alleges conspiracy to defraud the state of Georgia layered. Under Georgia legislation, a RICO conviction alone carries a mandatory minimum sentence of 5 years and a maximum of 20 years. If additional counts were to result in convictions and sentences were accumulated, potential vulnerability could extend for decades. Allow that to register. This isn't symbolic vulnerability, it's custodial vulnerability. And the strategic advantage of RICO is profound. Each member of an operation can be held responsible for actions executed by other members if those actions furthered the common objective. Prosecutors don't require proving that Donald Trump personally carried out every alleged action. They require proving that he knowingly participated in the operation and understood that it was engaged in a configuration of racketeering conduct. That shifts the battleground again. The 18 co-accused include attorneys who functioned on electoral challenges, legal advisors, political operatives, and individuals allegedly connected to the Coffee County voting machinery breach. Some have confronted accusations in other proceedings. Others are newly designated here. This is where institutional leverage enters. In RICO prosecutions, co-accused create pressure. Cooperation arrangements become possible. Testimony can cascade upward. If even several participants were to cooperate, according to standard prosecutorial practice, the operation theory strengthens, and that possibility is component of the design. Legal experts observing the indictment have noted its density. They indicate cited text communications, emails, recorded conversations, gathering timelines. The structure suggests a long-running investigation and careful assembly. This wasn't drafted overnight. The defense, for its component, has framed the indictment as an attempt to criminalize political behavior. They contend that contesting electoral outcomes falls squarely within constitutional protections. They have signaled that motions to dismiss will be filed and that they believe the accusations will not withstand legal examination. That's not merely rhetoric. It's a constitutional counteroffensive. If courts accept that the behavior alleged was protected political advocacy, the RICO framework weakens. If courts accept that the behavior crossed into synchronized criminality, the framework hardens. At a press conference, Fani Willis emphasized that the prosecution is grounded on evidence and legislation, not politics. She contended that RICO is appropriate precisely because the alleged behavior wasn't isolated, but component of a synchronized and extended scheme. She declared that there would be no special treatment. Processing would follow standard Fulton County procedures. Trial, she indicated, is anticipated in the summer, though pretrial motions could extend the timeline. Then arrived an image that redefined precedent. Donald Trump reported for processing at the Fulton County Jail. Booking procedures. A mugshot. Standard administrative steps applied to a former president of the United States in a state criminal case alleging organized criminal behavior. This is where the institutional shock becomes visible. A former president subjected to county jail processing under a state racketeering legislation. And we return to the structural constraint that matters most, because this is a state prosecution. Even if Donald Trump were to regain the presidency, he would not have authority to pardon himself for these accusations. Georgia's pardon authority resides with the Georgia State Board of Pardons and Paroles. The executive branch in Washington has no reach here. Federal authority stops at the state boundary. That reality transforms political calculation into legal confinement. Experts also caution that RICO convictions, once secured by a jury finding of an operation and a configuration, can be difficult to overturn on appeal. Appellate courts generally defer to jury determinations of fact as supported by evidence. So if a jury concludes that the operation existed and that Donald Trump knowingly participated in it, the appellate path narrows. This isn't merely a prosecution. It's a stress test of federalism. A state invoking its organized crime legislation against a former national executive. A defense invoking constitutional protections of political expression. A judiciary asked to draw the boundary between advocacy and conspiracy. And beneath all of it, a jury in Fulton County that will ultimately decide whether this was a hard-edged political campaign or a synchronized criminal operation. The next phase will determine not just accountability, but the boundaries of state authority over national political actors. What's unfolding in Fulton County is widely viewed as a legal turning point in modern American history. A former president isn't simply being accused of misconduct. He's being accused of leading a criminal operation aimed at interfering with a state electoral process. Allow that to sink in. This isn't a federal indictment constructed around classified materials or obstruction inside Washington. This is a state prosecution, a sovereign state invoking its own criminal code against a former national executive. That distinction matters more than most people recognize. First, this is a state case. The authority flows from Georgia legislation enforced by a locally elected district attorney, adjudicated in a Georgia courtroom. Second, the authority of pardon doesn't reside with the President of the United States. It resides with the Georgia State Board of Pardons and Paroles. The White House cannot reach into this process. Third, the RICO mechanism expands criminal accountability beyond individual actions. It binds behavior into operation. It transforms coordination into vulnerability. This is where the institutional stakes escalate. If a jury in Fulton County determines that an operation existed and that Donald Trump knowingly participated in a configuration of racketeering conduct, the legal consequences could be severe. RICO conviction alone carries a mandatory minimum of 5 years and a maximum of 20 years under Georgia legislation. Additional convictions could extend potential incarceration for decades. That's not theoretical. But the inverse is equally consequential. If the defense persuades the court that the alleged actions fall within lawful electoral challenges protected by the First Amendment, the RICO framework could weaken significantly. The boundary between aggressive political contestation and criminal conspiracy would be redrawn in real time. This is where the case ceases being about one accused and becomes about constitutional boundaries. The presence of 18 co-accused intensifies that dynamic. In traditional RICO prosecutions, cooperation arrangements often shape outcomes. Lower-level participants sometimes enter plea arrangements. Testimony travels upward. Leverage accumulates. If that configuration were to emerge here, according to established prosecutorial practice, the operation theory could gain strength. If solidarity holds and no cooperation materializes, the state must rely entirely on documentary evidence, recordings, and witness testimony already secured. Either way, the structure of the case creates pressure points. Observers have noted the level of detail in the indictment, telephone communications, text messages, gathering schedules, documents. The architecture suggests prosecutors believe they can meet the burden of proof beyond a reasonable doubt. That standard is high. It's designed to be high, and it will be tested in a Georgia courtroom. The Georgia state court framework now becomes the arena where this collision plays out. Judges will rule on motions to dismiss. Constitutional arguments will be argued. Pre-trial hearings will define evidentiary boundaries. Ultimately, a jury in Fulton County will decide whether the alleged behavior constitutes a hard-edged political strategy or an organized criminal structure. This is unprecedented territory. Never before has a former president confronted a state racketeering prosecution alleging leadership of a synchronized operation to modify an electoral outcome. This isn't normal. And regardless of outcome, the precedent is already forming. If the prosecution succeeds, it establishes that state organized crime legislation can reach into the behavior of national political actors when state electoral processes are implicated. If the defense prevails, it could reinforce constitutional protections around electoral challenges and political advocacy, limiting how extensively state criminal legislation can extend into post-election disagreements. Either result reshapes institutional expectations. The procedural timeline also matters. Pre-trial litigation could stretch for months. Motions to dismiss may test the outer limits of RICO application. Constitutional inquiries may rise through appellate channels. A public trial, if it proceeds, would position evidence and testimony before a jury under intense national examination. This is where the long arc comes into view. The American framework is constructed on layered sovereignty. Federal authority, state authority, local enforcement. Here, a state asserts its prerogative against a former holder of the highest federal office. The balance between those layers is being tested in open court. And so the deeper inquiry emerges. When state criminal legislation intersects with national political authority at this scale, does it strengthen the principle that no office holder stands above the legislation? Or does it risk transforming political conflict into permanent prosecutorial warfare between parties and jurisdictions? That's not an inquiry a single verdict can fully resolve. But it's the inquiry this case forces the country to confront.